Mary McCord is the former acting assistant attorney general for national security at the Justice Department. Glenn Kirshner is a former federal prosecutor. Lisa Rubin is an MSNBC legal correspondent. All of them have been following this trial very, very closely, and they join me now. So, Lisa, I'm going to start with you because you've been in that courtroom. You've been there almost every day, maybe every day. You've been covering this every day. Sorry, I didn't mean to cut you short there. We know Josh Steinglass is a meticulous and organized storyteller. I mean, that's my definition of just hearing the reporting and reading the transcript from the opening statement. What do you expect in terms of what he'll say, what's important for him to say, and how it will be structured tomorrow?
I think Josh Steinglass is finally going to put together a chronology from all the disparate pieces that we've seen so far, Jen. And we have seen testimony from so many different people and data and other documents from disparate sources, everything from phone record providers to the Trump organization itself. And so I expect that Josh Steinglass is going to take the jury through how the conspiracy was formed, how we know Donald Trump himself was not only a part of that conspiracy in a broad sense, but okayed the payment to Stormy Daniels. And then moving on to the period in which he was president, how we know that he okayed the repayment scheme that Alan Weisselberg and Michael Cohen came up with, and then executed the checks, 9 of them personally, to Michael Cohen all throughout that period. And then they're going to take us to a period beyond the point where Michael Cohen was receiving checks to all the different episodes that show what Mary and Glenn will know as consciousness of guilt, statements that Trump made in litigation, in his financial disclosure form, and even on Twitter that show he knows full well exactly what this was. It was a repayment for a hush money payment to Stormy Daniels, not payments for legitimate legal services.
So, Mary, that's a lot to pack into a closing argument. You know, a lot of what was in the opening, which was interesting, it was storytelling in kind of an edgy way that average people who weren't lawyers could understand. What is most important in your view in this closing argument that the jury needs to hear and digest and understand?
Yeah, a few things. I mean, he wants to continue the storytelling in the sense of, we've now told you the story. Here's the evidence, and I agree with Lisa. He'll set out a timeline, and he'll go through it chronologically. Here's the story that we told you in opening. Here's how we proved it up through the evidence that was admitted at trial. I think crucially as well, he will show how basically the government, the people, as they call them when it's in a state court in New York, the people established really the elements of this crime even before they got to Michael Cohen, so that he will try to minimize the necessity for Michael Cohen's testimony, Michael Cohen's evidence, and have the jury understand that the case was pretty much proven, and then Michael Cohen just tied it all up, filled in some gaps, but everything that was critical that he said that is necessary to find Mr. Trump's guilt had already been corroborated and proven through other witnesses, through exhibits, through Alan Weisselberg's notes on the actual documents that were actually the bank records that Michael Cohen had, the notes about how the repayment would be made, all of these things. So I think that's going to be very, very important for him. The defense, on the other hand, is going to hammer Michael Cohen's credibility and try to suggest that Michael Cohen was acting completely independently. To the extent there was a conspiracy here, it was a conspiracy between Michael Cohen and David Pecker and, Keith Davidson, but not Donald Trump.
The Michael Cohen acting roguely just doesn't even make sense as a human being. But again, I'm not a lawyer. Glenn, I want to go to you because you wrote a piece this morning that had a lot of interesting pieces in it. But as Mary just said, I mean, a lot of their strategy seems to be around Michael Cohen's credibility. And you basically argued in your piece that Michael Cohen admitting to his lies may help with the jury and credibility, right? He did admit to it pretty quickly. You also wrote about how you would handle the issue of the phone call, which was kind of a big moment during the last couple of weeks that Cohen may have mixed up in terms of the date or the content of it. Tell us more about that, your strategy and the Cohen piece of it.
Yeah, I agree that they will hammer on Michael Cohen. But the good news is, Jen, the jurors don't check their common sense at the courtroom door. They bring it into the jury box, they bring it into the deliberation room, and they're going to view the evidence through their sort of common sense lenses. And I think one thing that will likely resonate with them is the question, who benefited from this crime? Certainly not Michael Cohen. He wasn't running for office. He didn't get elected president of the United States. In fact, it sounds like he had to sneak around and hide from his own wife the fact that he was opening a home equity line of credit to make this, corrupt hush money payment. Why? To try to help Donald Trump win elected office. That is the kind of common sense argument that will resonate with the jury. With respect to the phone call, I frankly chuckled to myself as a former career prosecutor when I heard people, swooning over just how damaging that was to Michael Cohen's credibility. Think about this. Michael Cohen did not accurately remember whether he told Donald Trump in a phone call on a Tuesday or a Thursday, hey, boss, I made the payment. Now, first of all, I would ask the jurors, ladies and gentlemen, do you remember chapter and verse, the time of each phone call 8 years ago? You may remember the substance of a consequential call, but you're not going to remember the date and the time. And more importantly, as much of a cheapskate as Donald Trump is, do you really think he would have started writing $35,000 reimbursement check if Michael Cohen hadn't told him, hey, boss, I made the payment. I want my money. These are common sense arguments that will resonate with the jury. And I think the defense overplayed its hand in any number of ways, including, and maybe we'll get to this, insisting that Donald Trump had no sexual encounter with Stormy Daniels. Boy, is that going to come back to bite them.
That was such a strange part of I think it was in the opening statement of Todd Blanche, right, where they kind of insisted on that. Lisa, let me ask you about that piece, because it is this credibility component seems like it's a big weight for how both sides are thinking about the jury. And as Glenn mentioned, there's the did he or did he not have sexual relations with Stormy Daniels? But there's also this credibility of Michael Cohen. I mean, how did you play that if you're the prosecution?
Well, I think I would take Stormy Daniels separately from Michael Cohen. Let's talk about Michael Cohen first. I think the way you play that is, as Mary was suggesting, about minimizing Cohen and really focusing on all the other ways they've established critical facts, and chiefly through two people's testimony, David Pecker and Hope Hicks, each of whom were absolutely devastating to Donald Trump. So when you were talking about earlier, when Glenn was saying for whose benefit was this scheme, certainly not for Michael Cohen's, one answer to that is, of course, it was for Donald Trump's, because why else would Donald Trump throw David Pecker essentially a thank you party from the White House in July of 2017, where he said to Pecker, according to Pecker's testimony, invite whoever you want. This is a thank you for you. Well, what the heck else is Donald Trump thanking David Pecker for, other than saving his behind in the general election by burying not only one, but two stories that could have had a devastating impact on his campaign in the wake of the Access Hollywood tape? In terms of Michael Cohen and his own credibility, the way that you shore up that credibility is similar. You show all the ways in which the documentation and other witnesses support Cohen. So, for example, Hope Hicks, by taking a dig at Michael Cohen, actually shored up his credibility. She said, I didn't believe for a second that when Trump was telling me Cohen made this payment out of the goodness of his own heart, that's the way that all went down. And when she was asked why, she said, because that wasn't the Michael Cohen I knew. The Michael Cohen I knew was the first person to take credit for anything. He was not a selfless and generous human being. That's the way you establish Michael Cohen's credibility, even if it means taking a knock at him in other dimensions of his life.
Yeah, I mean, the corroboration of it by so many witnesses is such an important component of this. So, Mary, I feel like everybody this is the thing people are texting me is like, how long will this take? We don't know. As everybody's becoming a lawyer. So one of the things I read about is that the jury is not allowed to take the instructions with them, which I think might be standard in New York. We could certainly ask Lisa that question, or maybe you all know the answer to that question. How do they do that? Do they take notes? Do they go in there? Is there any tea leaf reading you're going to be watching for their timeline of deliberations?
Yeah, and I think part of the reason that some courts decide they're not going to give the jury instructions to the jury is they don't want people who end up having questions and going back to it then playing lawyer themselves and interpreting that language. So the court wants, if there's a question about instructions, the court will want the jury to ask the judge, their question.
And the judge will then talk to the jury
exactly.
again.
And
Yes.
that way it's coming from the judge. So they are going to be relying on memories. And you'll recall also that at the beginning of this trial, the judge allowed them to take notes. And another thing I expect that you'll hear in jury instructions is your notes are not evidence and your notes are not proof. Use them as an aid to refresh your recollection. But, you know, people should understand people make mistakes in their notes and don't rely too much on that because, you know, sometimes once people have written something down, they get very...
They take it as fact.
They take it as fact, right? But of course, that's not the case. So those kind of instructions will be there for the jury. In terms of how long it takes, I mean, there's just no way of knowing. What they don't need to do, what you often start other federal trials with, is electing a foreperson. We already have a foreperson because it's just the first juror selected in New York. But they will go through, there are 34 counts, but the proof for each is going to be pretty similar, right? The instructions will tell them what elements they have to prove in order to find guilt. The people had to prove in order for them to find guilt beyond a reasonable doubt. I think in addition to the different alternatives you mentioned at the top of the hour about what the jury might do, there's another possibility too, which is a mixed verdict, right? It is possible. I'm not suggesting they should do this or that the prosecution didn't prove its case for all 34 counts, but they could view the first few counts relating to payments that were actually when the reimbursements were coming from the Trump organization, the Trump Revocable Trust, signed not by Donald Trump as president, but signed by those still working for the Trump organization. They could view those differently, for example, than the 9 counts where Donald Trump himself was signing from the White House, for goodness sakes, and where they've heard evidence that those invoices were sent personally to Keith Schiller to be brought over to him to sign. So you could see potentially some breakdown between some counts finding not guilty, some or hanging on, not having all 12 agree, because an acquittal means all 12 have to agree. I find that highly unlikely, to be honest, in this case. But you could have breakdowns like that, and that takes time.
Yeah, that's an interesting, all things to watch.